Today we're going to speak about the difference between a broker and an agent, or an independent agent and a normal insurance agent. A broker is never an agent of the insurer. In Michigan, a broker is called an independent agent and is considered to be a person who represents his principal, the insured. In Michigan, the common law considers an independent insurance agent to be an agent of the insured who places business with an insurer but is not an agent of the insurer. When an independent insurance agent is ordinarily an agent of the insured, not the insurer, while on appeal, the Court of Appeals was asked whether to decide if the legislature abrogated this principle of Michigan's common law when it amended the insurance code. In Ahmed al-Hajjaj versus Hartford et al., a decision of the Michigan Court of Appeals dated January 26, 2023, the key question was whether the legislature abrogated the principle of Michigan's common law when it amended the insurance code. Ahmed al-Hajjaj is the owner of Prime Transportation Services, LLC, and he sought insurance coverage for Prime's vehicles from Golden Insurance Agency, LLC. Al-Hajjaj talked with Sam Saidi, a principal and insurance agent of Golden. Golden is an independent insurance agency that places policies for over 10 different insurers, including Hartford Accident and Indemnity Company. Saidi recommended that Al-Hajjaj purchase a policy for his company through the Hartford, and Al-Hajjaj agreed to do so. The policy application that Saidi filled out with Al-Hajjaj listed Prime LLC as the company as opposed to the full name Prime Transportation Service LLC. More critically, the application incorrectly indicated that the company was a physical therapy office that did not transport patients, when in fact the company provided medical transportation services for patients. Based on the application it received from Golden, Hartford issued an insurance policy to Prime LLC, a non-existent company. Al-Hajjaj was subsequently injured in a vehicle collision, and he sought personal injury protection benefits from the Hartford. As part of its coverage investigation, Hartford discovered the errors in the application. The insurance company rescinded the policy based on what it characterized as material misrepresentations in the application, and Al-Hajjaj sued Hartford, Golden, and others. Plaintiff argued that Golden, the insurance agent, was a contractual agent of Hartford, the insurer. Golden had a contract with Hartford that only gave the agency the authority to solicit, quote, and bind insurance for certain lines of insurance offered by the Hartford. The insurer could cancel any policy that Golden placed with the insurance company, and as a limitation on the relationship, the agreement provided, quote, limitations. You, Golden, have the authority and power to act as our agent only to the extent expressly granted in this agreement, and no further authority or power is implied. You are an independent contractor and not an employee of ours for any purpose, and your right to represent other companies is not restricted by this agreement. Any authority granted hereunder to solicit, quote, or bind insurance products on our behalf is non-exclusive unless we agree otherwise in writing, close quote. Al-Hajjaj also argued that the legislature abrogated Michigan's common law principle that an independent insurance agent was an agent of the insured, not the insurer, for purposes of applying for and placing insurance policies. The trial court denied Hartford's motion for summary adjudication, concluding that the contractual relationship between the Hartford and Golden meant that the latter was the agent of the former. With respect to statutory interpretation, the court is required to give effect to the legislature's intent. The legislature is presumed to intend the meaning clearly expressed, and the court must give effect to the plain, ordinary, or generally expected meaning of the legislature's terms. There were two issues before the Court of Appeal. One, whether the legislature abrogated the common law principle regarding independent insurance agents, and if not, two, whether the contract between Hartford and Golden made the latter the agent of the former for purposes of any errors in the application. The record confirmed that Golden is an independent insurance agency, not a captive one. It offers to place policies from at least 10 different insurance companies. It has long been the common law of Michigan that when an insurance policy is facilitated by an independent insurance agent or broker, the independent insurance agent or broker is considered an agent of the insured rather than an agent of the insurer. This principle makes sense in the context of an independent insurance agent who can offer a single customer an array of options from any of the insurers with which the agent has contracted. A customer can approach an independent insurance agent and expect to comparison shop between all the available insurers, unlike when a customer goes to a captive insurance agent who has but one insurer to offer. An independent insurance agent who had to balance fiduciary duties of loyalty between competing insurers would effectively be frozen into inaction by a web of crossing and conflicting duties and interests. Instead, in recognition of the materially different circumstances faced by a customer who deals with an independent insurance agent versus a captive insurance agent, courts have concluded that the independent insurance agent owes its primary fiduciary duty of loyalty to the customer. Al-Hajjaj argued that the principle of common law was abrogated by the legislature. Prior to enactment of the new Public Act, MCL 500.1201 paren A close paren defined agent as an insurance producer, and in turn subdivision E defined insurance producer as a person required to be licensed under the laws of the state to sell, solicit, or negotiate insurance. Where Al-Hajjaj sought an insurance policy through Golden, an independent insurance agent, and not through an agent-to-agent transaction, the independent agent only represents the insured. Hartford and Golden entered into an agency agreement which covered Saedi as a principal of Golden. By all accounts, this was a standard contract between an insurance company and an independent insurance agent. The contract authorized Golden to solicit, quote, and bind insurance on behalf of Hartford, but the contract also materially limited Golden's authority. Moreover, the contract recognized that Golden was an independent insurance agent that had the right to select and place insurance policies with other insurers. The Hartford-Golden contract established that the independent insurance agent or broker is considered an agent of the insured rather than an agent of the insurer. Here, Golden owed its primary fiduciary duty of loyalty to Al-Hajjaj as its customer rather than to Hartford as one of the 10 insurers for which it placed policies. Given the standard language used in the contract between an independent insurance agent and insurer here, the trial court erred in concluding that the independent insurance agent was the agent of the insurer in this instance, and denying summary disposition on that basis. The Court of Appeals reversed and remanded for further proceedings consistent with its opinion. Independent insurance agents continue to owe their primary fiduciary duty of loyalty to their customers, that is, the insureds rather than the insurance companies whose policies they place. This common law principle survived the legislature's amendment to the insurance code. The trial court erred when it concluded that the contract between Hartford and Golden altered the principle. In my opinion, an independent insurance agent in Michigan is similar to a broker in California, who is defined as a person who transacts insurance with, but not on behalf of an insurer, and is therefore only concerned with its duty to the insured. A minor statutory change in definition did nothing to change the fact that the independent insurance agent's obligation in Michigan is to the insured.